This video is Orders of Protection. What is a 10-day hearing and how should you prepare for one if it is scheduled? Brought to you by the New Mexico Judiciary, presented by Rosemary Traub and Sarah Coffey. The information presented in this video does not and is not intended to constitute legal advice. All information in this video is for general informational purposes only. Information in this video may not constitute the most up-to-date legal or other information. Viewers of this video should contact an attorney to obtain advice with respect to any particular legal matter. Only your individual attorney can provide assurances that the information contained herein is applicable to your particular situation. The views expressed in this video are those of the author or authors only.
We're going to move on to the hearing. It's called a 10-day hearing. And the 10-day hearing, you will have notice of it. You will have the date and the time and the name of the hearing officer on the third page of the temporary order of protection. And so you need to be available. And as Sarah stated, now the specific directions are that you call. There's one number to call 15 minutes before the hearing. They will give you the 800 number and the access code. And those two numbers you need to call in at the time of the hearing. We have a lot of people who they do both 15 minutes before the hearing. So keep that in mind. So at the 10-day hearing, several things can happen. What we do is that we wait till both parties call in and we make a record. The hearings are being recorded and both parties are sworn in. And then I ask the petitioner, which may be you, if you still want the order of protection to be extended. And if you do, I ask the other party if they agree to that. Some people do. That, if there's an agreement to an order of protection, that is called a stipulated order of protection. And what I think you need to understand about a stipulated order of protection is that if that happens, the court is not going to hear any evidence. And the court is not going to make any decision or what's called a finding that the other person committed an act of domestic abuse, stalking, or sexual assault. It's an agreement. It's an agreement in a court order called an order of protection. And that is the only difference, is that there's no finding by the court. And what we do is we fill out the stipulated order of protection while both parties are on the line. And then it will get sent out to both parties. The alternative is a hearing. And during the hearing, normally these are set for half an hour. So we have to move rather quickly. So in a hearing, the petitioner, whoever asked for the order of protection, would present their evidence, then the other person has the opportunity to respond. And then the court makes a decision on whether or not there was an act of domestic abuse, stalking, or sexual assault, if they're by a preponderance of the evidence. This is not a criminal case. This is a civil case. So it is not beyond a reasonable doubt, which maybe you've heard on TV or somewhere else. This is a little bit more than 50%, okay? And so if that is granted, then again, information, the hearing officer will get information from both parties to fill out the order of protection. And if a custody, child support, or property attachment is needed, that will be filled out. And then it needs to be submitted to the judge for approval and then sent out to both of you. The only other alternative is that if there, I will just mention it, I'm not going to explain it, but if there is already a domestic matters case, such as a divorce or a parentage case, it could be that a stipulated no contact order could be entered in that case instead of an order of protection.
So let's talk about how to prepare for the hearing itself. As you heard, the hearing is scheduled for 30 minutes, which means that you get 15 minutes and the other side gets 15 minutes. So you really, really need to focus on the information you want the commissioner to hear about. You need to tell the commissioner all the relevant domestic abuse. I always recommend, before you go into the hearing, writing out some bullet points so that way if you get nervous, you have something to reference. And that way you also make sure that you don't skip something very important because you're nervous, because you can just kind of check those off as you go along. But tell them all the relevant information. You don't get a second chance to tell them that. So if you forget something, that's not good. So like I said, I'd write it out beforehand. That way you can make sure that you're covering everything in this hearing. Some people are just going to call in and just tell the commissioner what's been going on. Other people might have some actual evidence to present other than just what they have experienced and what their testimony is. Evidence can include photographs. So if there are injuries, if you have injuries from the domestic abuse, if property was damaged in the domestic abuse, you can take a picture of your injury or of the property damage and you can submit that to the court. Text messages, if there are threats or something that you think is relevant to the domestic violence in a text message, you can take a screenshot of that text message and send it into the court. If you have a voicemail, or if you have a security system, so a video captured something that you think that the court needs to see, those things can be submitted as well. Once again, you only have 15 minutes. So when you look at all of the things that you have, because you might have a lot of different things, you really want to look at what is the most important thing for the judge to see. Because ultimately, you only have a short amount of time and you certainly don't want to waste that on things that aren't as relevant. Sometimes, even if you have additional documentation, the thing that is the most relevant is your testimony about what happened. More often than not, that should be the bulk of what you do, is you tell the commissioner what has happened. The evidence is extra. So really focus anything you have like that. The last thing you can do is you can call witnesses. So witnesses are another thing that you need to be really careful and think through whether or not this person helps you exactly show that you are the victim of this domestic abuse. So generally, if the witness physically saw the domestic abuse happening, that might be a good witness to call. If the witness heard the domestic abuse, so if they were in the other room and heard what was going on, that person might be a good person to call. If you had substantial injuries but did not take a photograph of it, you might think about calling a witness just to testify that you had the injuries. Otherwise, if it's just witnesses about general behavior of the other party, or general behavior that you had, those usually aren't as helpful of witnesses, and you would probably not call them because you want to focus on the domestic abuse for your 15-minute time frame. So really think that through and decide what's best to show the court of what's going on in your life. Remember walking in that the court does not know your situation. The court doesn't know what's been happening. You have to explain the history and what's going on. I wouldn't spend a whole lot of time on history, but sometimes history is really important. And if that's the case in your situation, I would take a minute or two and give that brief history and then go into what's been going on. Because this is your opportunity to open a window into what's been happening, is this hearing. So really think before you go into it of what you want the court to know.
Okay, I'm going to add a little bit more information about that's very COVID specific. And it's probably the area where we have the most trouble, frankly. And so with the paperwork that you get, usually at the very back is a 2-page order that is called Order Regarding Exhibits in Domestic Violence Cases. It's in small print, and it's also it's in English and in Spanish. And my experience is that most people don't read it, and that's unfortunate. And I understand that having all of that paperwork in the midst of what is going on and what you're trying to get done for yourself and perhaps your children can be overwhelming. And I totally understand that. But as soon as you can recoup from that and really focus, you need to read over that order and follow it. And here are the reasons. Number one, all evidence that you want to present must be provided to the court at least 48 hours before the hearing. Okay? And there is no wiggle room on this. No wiggle room. So if there are documents, and they are up to 10 documents, they can be emailed. Keep in mind, they need to be sent to the other party also. Okay. If it's more than 10 pages, hard copies have to be brought to the court. So what's going on in the hearing is, so if you were if we were non-COVID and you came into the hearing, you'd have to have 3 sets of your exhibits. One for you, one for the other person, and one for the court. This is the same thing. It's just getting sent in a different way, okay? And so the other party needs a set. The order talks about email, but it can be sent by regular mail. And I want you to be aware of that. It is not a violation of an order to email or send exhibits and documents or a thumb drive to the other person. And in fact, you're required to do that, and that needs to be 48 hours before the hearing also. Obviously, a set needs to be provided to the court at least 48 hours before the hearing, okay? And again, if it's over 10 pages, you're gonna have to bring in hard copies, okay? And you're gonna have to bring in a thumb drive or a CD, okay? Otherwise, it can be emailed in. So read that order. If you have questions, please call the domestic violence clerk. The number is 505-841-6737. They are, in my opinion, exceptional clerks, and they bend over backwards to help people. Let's see. You can provide thumb drives, but remember when you put thumb drives, I just had a case where I had 101 exhibits from one side, and I think I had 94 from the other side. And I understand that from a personal point of view, they all feel important. I totally understand that. But as far as trying to prove that an act of domestic abuse, stalking, or sexual assault occurred, you really need to focus in on and really look at it and focus in on what will convince the court that that happened, the best evidence that will convince the court. And that's what's really necessary. It isn't volumes and volumes. Sometimes we get binder after binder. That's not really the measure of whether you've done a good job preparing or not. It's the quality of what's in there, okay? Again, call in before your hearing, 15 minutes before it starts. So if it starts at 9:30, call into the clerk's office, the 505-841-6737, and they will give you the 800 number and the access code. Wait hang on to that information, and call in at the time of the hearing. Okay? And the court will wait for both parties to call in. Each hearing officer has their own barometer as far as how long they will wait. Now, we also have interpreters for people who need them. We have interpreters for Spanish here at the court who also call in and are available if there is a language like Lao or Thai or French or something. We may get somebody on the language line. So we can, the court will accommodate that. And the interpreter will work with, if you are the one that needs the interpreter, they will work with you on how that's going to happen during the hearing, because they'll be calling in too. The other thing, one thing I do want to mention is if you want to present text messages that are in another language, I have, for this presentation, I did talk to the interpreters here about that. If it is 1 or 2 lines, the problem on the phone is they may not have access to it, and so there's nothing that they can do. But if it were provided to them beforehand, okay, they might be able to interpret it. Okay, but otherwise, that needs to be done well before the hearing, translated into English. So just keep that in mind. The interpreters will do everything that they can, but again, we're under a pretty tight timeline and need to get hearings done within a half an hour.
If you need help or if you have questions, New Mexico Legal Aid does have our domestic violence helpline. You can call that Monday through Friday, 9 to 5. The phone number is 1-877-974-3400. Once again, that's 877-974-3400, and see if New Mexico Legal Aid might be able to assist you.
And we both hope that this has been helpful to you if you need to file an order of protection.